Good morning, good afternoon, and good evening, everyone. Today, on behalf of the United Nations Institute for Training and Research, it is my pleasure to welcome you to the open webinar on Blaming the Brain, Criminal Responsibility, Addiction, and Neuroscience. My name is Viviana Grande, and I'm part of UNITAR's Division for Multilateral Diplomacy. Today, I will be moderating this webinar, and I will be supported by some of our UNITAR colleagues. I would like to mention that this webinar is presented in anticipation of the Executive Diploma on Law and Neuroscience, a Comparative Approach, offered by UNITAR during fall 2023 in collaboration with Maastricht University and the Center for Law, Brain and Behavior at Massachusetts General Hospital, Harvard Medical School. This program will be taught via Zoom and will have a 5-week duration, with each week covering different topics, such as the insanity defense, coercive use of neurotechniques and human rights, and related policy and legislation issues, also including case studies and other practical components. Furthermore, all these topics will be addressed through a comparative law approach, considering both US and European jurisdictions. Finally, for those interested, this training program is slated to commence on the 4th of September 2023, and registrations are already open on our website. But now, going back to the reason why we are here today, be aware that during this webinar, we will examine criminal responsibility in light of neuroscience models of addiction, psychiatric illness, decision-making, and volition through comparative law lenses. The relevance of all the topics which will be addressed today stems from the impact that advances in neuroscientific research and technologies are having nowadays in the field of law, particularly criminal law, and the empirical, practical, and ethical questions that they raise. I'm thus delighted to introduce our known experts in the field of law and neuroscience. Our main speakers during today's sessions are Anna Goldberg, Assistant Professor of Criminal Law at the University of Groningen, David Ruff, Associate Professor in Criminal Law and Extraordinary Professor of Criminal Law and Neuroscience at Maastricht University, Robert Kincher, a clinical forensic psychologist and attorney serving as Executive Director of the Center for Law, Brain and Behavior at Massachusetts General Hospital, Harvard Medical School, and Judith Edersheim, co-founder and co-director of the Center for Law, Brain and Behavior and Assistant Professor at Harvard Medical School. We also have the pleasure to have with us other esteemed experts in this field who will be contributing to the discussion. Welcome to Marko Jelicic, affiliated with Maastricht University. He's an associate professor in forensic psychology at the Faculty of Psychology and Neuroscience and a professor of neuropsychology and law at the Faculty of Law. Caitlin Tabor, senior researcher at the Center for Law, Brain and Behavior at Harvard Medical School, and Ruben Knehans, PhD researcher at Maastricht University. Thank you all for being with us today. Before giving the floor to our experts, I would like to inform you that this webinar will be concluded with a 30-minute Q&A session. But should you have any questions or comments before then, please write them in the chat or use the Q&A function, and we will either include these during the discussion or address them at the end of the webinar. With that said, and without any further ado, dear experts, the floor is all yours.
Thank you so much, Viviana. I'm going to lead off. I'm very lucky to be in this esteemed panel, and I want to welcome all of those of you participating in the webinar. This should be wonderful. So I'm going to share my screen, and I hope you can see it. How's that looking? You should be able to see my slides, and I'm going to go at a very rapid clip. We want to give you plenty of time for Q&A. So I have a total of 7 minutes. This is going to be a whirlwind tour. Maybe I'll have 8. But my goal for the next 7 minutes is a very brief overview of law and neuroscience and an introduction to the neuroscience of substance use disorders to set the stage for how it might appear and impact criminal law. That's my job. And then I'm going to turn this over to Dr. Goldberg, who will discuss the implications for law in general and criminal law. So, let's see. Doesn't want to do that. Okay, now we're going. You've seen an introduction to the panelists. This is the briefest overview you'll ever have of law and neuroscience, but it will set the stage. Neurolaw is everywhere because at essence, law regulates human behavior, the nature of personal responsibility, and the consequences for transgressing social rules. And because human brains generate human behavior, this is why this is at the center of a controversy and has great implications for justice, social justice, and law reform. So I'm going to, in this overview, leave out some of the more futuristic manifestations of the field and just stick with what is grounded and known. So in criminal law, the focus has really been on using neuroscience to elucidate mental states. At the level of individual cases, this has been mostly to support insanity defenses as a basis for diminished responsibility or as mitigation evidence in sentencing. But at the level of legal policy, neuroscience and law has been used to reevaluate legal doctrines that actually rest on old faulty tropes about the brain, such as the myth that human memory is like a video camera, stored and replayed flawlessly, or that juvenile and young adult brains are the same as grown-up brains. In civil law, law and neuroscience is most known to, for example, substantiate or refute brain injury, to support or contest claims that are based on lack of cognitive capacity or competency. Sometimes the use of neuroimaging to substantiate or measure or refute the presence of acute or chronic pain. And finally, to support litigation about brains that are in decline, using structural markers for cognitive impairment. So today our focus is on the neuroscience of addiction and how this poses complex challenges for criminal law. And as you all know, substance use and crime have a very complicated relationship. Sometimes addiction is the background for some criminality. Sometimes addiction is the motivator for some criminality. And sometimes addiction is the enterprise of the criminality itself. We don't have time to go into all of this, but we should all have this in our heads, in the back of our minds today as a landscape. 1 in 5 incarcerated people in the US are incarcerated for drug offenses. This is heavily weighted in the federal system of our legal system because that is where nonviolent drug offenses predominate. And people in jail are almost 8 times more likely to have substance use disorders than people in the general population in the United States. So I wanted to lay that out for you as we progress through what the implications are here. So in contrast to the outdated views of addictions as moral failings or character flaws, we now understand, and this is a very basic and clear understanding, that substance use disorders are chronic illnesses that are characterized by impaired social functioning, poor health, impaired control over their own use. Although the disease mechanisms differ between substance disorders and other chronic disorders, they have a great deal in common, surprisingly, with other medical disorders that I've showed you in this chart, like hypertension, asthma, diabetes. All of these disorders are chronic and relapsing and remitting and influenced by genetic and behavioral and developmental factors and social factors as well. So as you can see as this personal, in the purple bar graph, the substance use disorders have similar relapse rates to other chronic disorders. And as with other chronic disorders, the downstream metabolic consequences of substance use can be visualized with sophisticated functional neuroimaging. So on the top, you can see functional imaging of brain metabolism with chronic cocaine use. And on the bottom is juxtaposed analogous decreased cardiac metabolism in chronic heart disease on the bottom. So like in the case of all chronic medical illnesses, social, environmental, and developmental factors, of course, influence the development of substance use disorders. And this is going to matter with respect to doctrines that Dr. Goldberg is going to talk about, such as prior fault, for example. So Adverse childhood experiences, so-called ACEs, or life stressors, are heavily associated with the onset of substance use disorders. So the research here points to the fact that the risk factors act on the same stress circuits that are recruited during substance use, and that is the current model to explain that additional risk. My little DNA strand there is to signal me to talk about genetic and epigenetic factors. So this is a shocking statistic for many. I think genetic factors are thought to account for about 40 to 60%. That's huge in individual differences in the risk for addiction. You have to keep in mind that substance use disorders, like other chronic disorders, are the product of interactions between gene and environment, and that this is a science that's really in its infancy. But genotypic variability and vulnerability to the addiction really is a representation of variability in the metabolism of a certain drug, and also in the sensitivity to the reinforcing effects of a particular drug. And finally, adolescence and emerging adulthood. I think everyone knows that adolescence is a critical risk period for the development of substance use, including cannabis and alcohol. And this has particularly harmful effects on a developing brain. My colleague Leah Somerville says moving parts get broken. And as the prefrontal cortex remodels itself during adolescence, this presents a tremendous vulnerability for emerging adulthood affecting brain development with substance use. So how does this happen mechanistically? I know I'm going quickly, but we can clarify in the Q&A. Dopamine. Dopamine is how it happens. The neurotransmitter dopamine is at the center of all drug reward, and dopaminergic stimulation is what causes the downstream neuroadaptations that are responsible for drug-induced structural and functional changes in the brain. Every drug that has addictive potential increases dopamine transmission, either through direct or indirect effects on the dopamine neurons in the ventral tegmentum, as I have on this scan, with eventual downstream release of dopamine in the nucleus accumbens on that slide. We're not going to go into other neurotransmitters and other recruitments, but dopamine is at the center of it all. So that's too far. Okay, so in this diagram, I want to show you the three regions that we think are most implicated in the brain for understanding how drugs disrupt volitional control. Using dopamine as a signal, they they hijack brain mechanisms that are involved in seeking reward and weaken brain mechanisms that are involved in inhibiting reinforcement. So in blue, the basal ganglia, those are structures deep in the brain which play a large role in learning, reward, and reinforcement and habit formation. In red, the extended amygdala regulates brain reactions to stress and negative emotions, anxiety, irritability, and flight or fight responses, hypothalamic responses. And finally, in the prefrontal cortex in green is responsible for executive functionings, decision-making, impulse control. I'll go into this a little bit later. So overlaid on these brain regions, also color-coded, is this famous model posited by Nora Volkoff and George Koob. And this slide is courtesy of NIDA. And this cycle is the well-known cycle of binge and intoxication, followed by withdrawal and negative affect, and then preoccupation and anticipation. So binge intoxication is the consumption stage, where an individual experiences negative emotional states when the substance isn't present. Preoccupation or anticipation is the stage of substance seeking after the period of abstinence from the drug. And all of you are familiar with that cycle. How you progress through this depends on the frequency and the intensity of use, but this cycle intensifies over time, and it leads to greater neurological and psychological harm. Eventually, the user experiences stress, and depression, and sometimes physical illness. And then when not using the substance, with perpetuates craving and the anticipation and the seeking of substances and the continuous reinforcement of this cycle. So I'm going to go through this color-coded model, linking the stage with the structure so that you can see how it's instantiated. I promise to do it quickly so you don't change the channel because of the brain science. So with binge and intoxication, the basal ganglia is all about incentive salience in blue. These are the deep structures of the brain that they do lots of things like mediate movement and memory and such things, but they're crucial for perpetuating substance use disorders. And two subsets in particular, the nucleus accumbens, which I talked about a minute ago with respect to dopamine. This is the center of reward and reinforcement, motivation to seek something. And then I'm going to talk, and then briefly, the dorsal striatum, which you can see there. It's involved in habit formation or routinized behavior. So dopamine signaling in the nucleus accumbens is responsible for enhanced motivation to seek rewards. And that goes not just for the drug itself, but also the linked cues to use, like the people you use with, the places you use, drug paraphernalia. And then the dorsal striatum is the habit circuit. The dorsal striatum changes underpin and strengthen the motivation circuitry of the nucleus accumbens. When there is no more drug present and you are no longer intoxicated, the cycle in red takes over. People who are addicted to substances become habituated to them, and the extended amygdala takes over because generally people who have addictions have a reduced sensitivity to all rewards in the brain. Now think about that for a minute. What that means is that those with substance use disorders experience a reduction in the brain's rewards for the drug itself, but also natural rewards like food or excitement. And so at the same time that the substance is becoming pound for pound less rewarding, the stress neurotransmitters in the extended amygdala in red are becoming more active. This is corticotropin, norepinephrine, dynorphin. These overactive stress responses actually produce negative emotions. And so you start getting negative emotions and bad feelings that motivate more drug seeking. Simply put, this stage of addiction involves a decrease in the function of brain reward systems and an activation of brain stress systems. And it's the drive to stop these negative feelings that pushes you to the next stage of craving and drug seeking. So finally, the prefrontal cortex. I said I'd talk about this in green. The prefrontal cortex is the region of the brain that controls executive functions, organizing, prioritizing, regulating impulses and actions and emotion. So after a period of abstinence, a person becomes preoccupied with using again, and we call that craving. And the prefrontal cortex, I'm going to talk in very colloquial terms. The prefrontal cortex, mostly the orbitofrontal cortex and the anterior cingulate, is impaired in its top-down or inhibitory role on controlling drug-seeking behavior. So this is really going to make a neuroscientist faint. But if we talk about the go system and the stop system, in cartoonish terms, the go system of the prefrontal cortex is overactivated, and you can see the projections on that slide. And it promotes substance seeking, while the stop system actually is inhibited. Those prefrontal cortical projections to the amygdala, to the extended amygdala, promoting impulsive and compulsive substance seeking. So in short, there is a defect in executive functions that is well associated with substance addiction. So that completes our circle. There are some downstream receptors that are recruited in dopaminergic transmission that we don't have time to talk about, but I think that really covers the cycle and its instantiation in the brain. And so lastly, before I turn this over, I have two final slides. The pharmacologic treatments that we're developing for substance use disorders are actually designed to address these neuroadaptations at the specific stages and manifestations that we've just gone through. I'm assuming you have a copy of these slides, or you will have them, and you can look at the drug targets and the inventions. But you can see that this knowledge has been very valuable for treatment. And what I showed you before, because I don't want to depress anyone, is that you can recover from addiction. And this is a slide which actually shows, it's a PET scan that shows how chronic methamphetamine use actually reduces the binding of dopamine to dopamine receptors, transporters in red and green, in the striatum, which is an area that is critical for movement and memory. But with long-term abstinence, you see recovery in those areas. So my final comment is that this neuroscience, and it's hovering between medical models and criminal models, actually poses quite a dilemma for notions of criminal culpability. How is it going to inform the legal system? How are these biologic mechanisms for drug craving, compulsion, and so-called brain hijacking going to square with legal concepts of volitional control and punishment? And for these questions, I'm going to turn over the talking to Dr. Anna Goldberg, who is a great expert in this area. And Anna, you'll tell me to advance slides or if you want to switch.
Perfect. Thank you so much. I'm afraid I won't be able to give you all the answers to these questions, but hopefully I can give an overview of the general framework in which these questions take place, and maybe provide you with some thoughts to think about these things. So yeah, thanks a lot for the useful overview on addiction and substance use. And just to really briefly recap what has been said already, by virtue of there being such a clear biological component to addiction and to substance use, and because addiction is so pervasively present in the criminal justice sector, it is just essentially a perfect example to illustrate the relevancy of the neurolaw discipline. So just in case you were wondering why this combination of addiction and neurolaw, I think we can really use neurolaw to sort of illustrate and use addiction as a case study within neurolaw to illustrate the different purposes and relevancy of neurolaw. Before I go to the next slides, there's a third angle actually that makes addiction particularly relevant as a case study. So in the context of responsibility and legal responsibility, addiction is quite a unique disorder compared to other mental disorders, for the simple reason that addiction can also be categorized as continuously making decisions that are ultimately not in your favor in terms of health and well-being, relationships, jobs, and so on. So aside from the biological component, it's also a unique disorder because there's such an importance of motivation if you want to stop using substances. And motivation and choice is so crucial in the progression of the disorder. What makes it interesting is that these aspects, the aspects of choice and responsibility that are fundamental to addiction, are also fundamental in law and crucial to the law. So that makes the discussion on addiction in the law such an interesting one. All right, I'd like to see the next slide, please. Perfect. All right, so the aim of this very, very brief overview is to just look at the peculiarities of addiction and then to evaluate some of the legal questions. And now that we have looked at addiction in more detail, I'm just going to take the brief outline of the legal relevance on me. And then I'll pass the virtual mic on to our two true legal experts to really get into detail of two legal systems. So the primary legally relevant factor of addiction, at least what I think, would be the capacity for control. So this has been mentioned already. I would also refer to it as volitional capacities here and there, and the element of choice. So from a legal perspective, we are looking at the question of responsibility and how much an individual needs to be in control to be considered responsible. So essentially at the core, and this is, I think, quite a universal idea, it seems that the law presumes individuals to be in control of their behavior. So we think that a reasonable person standard is somebody who's capable of controlling their behavior. So presumably, if you cannot exercise control and therefore your behavior is beyond your control, it doesn't make quite sense to hold them accountable for their actions. So this seems to be quite an intuitive notion, quite commonsensible, but actually we'll see that it requires a bit more detailed legal analysis to really identify how much control the law requires for responsibility. So I don't want to give too many spoilers, but I'm going to give a small spoiler anyway, but we will see that there's a large difference between common law systems and civil law systems when it comes to how much control is required for responsibility. But essentially, once we know the required impairments in control that the law requires, we can then identify whether addiction can actually cause such impairments, whether it can fulfill these requirements of the law. Well, aside from a legal question, it's also an empirical question. So it's just one thing to require control for legal responsibility in general, but it's another question to identify how much control somebody really had during the time of the offense. So aside from that, did the defendant not have any control, or did the defendant decide not to exercise this volitional capacity? So that is also another question that needs to be answered if we want to use it in the law. And relatedly, it also requires us to contemplate a little bit on the more practical matter on how we can make sure that we measure control, so how to be measuring it, and how reliable our measurements are of control. So it's quite nice that the law may or may not require control, but it's a different kind of question on how we can actually assess and evaluate the amount of control. And finally, just as a small side note, there's also a bit of a philosophical component to what control actually means, but also what control and volition, how it relates to voluntariness. So this is something that we see a lot if we look at addiction in the law, and we see arguments such as the drug use was voluntary. And this is then sort of used to imply responsibility. So voluntariness seems to be used as synonymous with responsibility. If you acted voluntarily, you acted responsibly, or you should be held accountable, I mean. But is that actually the same? So is voluntariness the same as being in control and being responsible? And how can we, or how should we, differentiate between these concepts? That's something I'd love to talk more about, but for today, the focus will be on the first matter, so the legal angle of this problem. And as another side note, I know there will be lots of side notes. Hopefully this is something we can bring up during the Q&A. But beyond these three basic domains that I just mentioned, there's a very interesting discourse to address the responsibility for being addicted. So these biological perspectives towards addiction that were presented just now, they also raise questions of responsibility, not just for your behavior at the time of the offense, but also for the disorder itself. So if we would argue that being addicted is, or is not, perhaps, your own responsibility, this would also have consequences for laws on, for instance, prior fault. And what I've noticed in Dutch case law, I sometimes see arguments in which the defendant is blamed for being addicted, and therefore he's held responsible for his actions. So just by virtue of being considered responsible for being addicted itself. So I think a discussion on addiction and responsibility and prior fault is also one that's inherently related to matters of stigma and bias and perception. So as a final side note on my half. All right, so next slide, please. I'd like to zoom in onto the first legal question, and that is that we need to identify what it makes or what makes up the concept of criminal responsibility. So which elements, are we looking at here? In the next two presentations, we will see that it strongly depends on the legal system, and that these legal systems are very strongly influenced by the way that criminal law is structured. So we know a bipartite structure in the US system, for instance, and a tripartite structure in continental Europe. And these different structures, they highlight the different elements that together make up responsibility. And you'll see that the role of addiction in these matters of responsibility also differ in where you're at in terms of structure. But regardless of the underlying structure, both systems do have an insanity defense or an equivalence thereof. And I think the insanity defense is also the most straightforwardly relevant legal concept to address in the context of addiction. So it'll be interesting to see the different criteria for these defenses, and they will be outlined in the later presentations. But it's also interesting to see that most continental systems, they have a general diminished responsibility defense. So especially for disorders that do not fundamentally fully eliminate certain capacities, such as capacity for control, but rather reduce these capacities to various degrees, a general diminished responsibility option is useful. So especially things like addiction that may impact your capacities, but not fully eliminate them, a diminished responsibility alternative is going to be really helpful. Other things that I'm skipping for now, but that we could hopefully discuss later, is also matters of premeditation, in cases of murder, requirements for prior fault, but also a very massive topic, things like sentencing, risk assessment, and so on. All right, then my final slides. I'd like to really briefly look into the case that was sent to you today, and then we'll dive into the American justice system. So you have read about the case of Haley, and you've seen some of the questions that this raises. So just as a brief summary and a recap, we can see that the most straightforward questions that it addresses is what the requirements are for legal insanity, whether addiction could fulfill these requirements in general, and then specifically whether that's the case for Haley. Then we can look at the factor that Haley was also intoxicated during the offense, which leads to certain questions on how intoxication further impacts the application of such rules. And then based on the slides at the start of the presentation, we can also consider the role of neuroscientific knowledge, neuroscientific evidence in answering these kinds of questions now that we know what happens to the brain. And ultimately, we also know that Haley has a history of comorbidity. So I personally think this is one of the most interesting parts of the questions. So does it matter which other psychological factors or disorders contributed to this whole cycle of substance abuse and then the offense? So yeah, up next, we're going to explore these matters a bit further. So first, we're going to look at the common law system, and then from a civil law perspective, and any remaining issues, such as some of the things I just mentioned a couple of minutes ago. They may still be asked in the chat. We can discuss them later during the Q&A and hopefully have a bit more of a discussion on it. So for now, thanks a lot for your attention. And I'd like to give the floor to the next speaker, Dr. Robert Kincherf.
Thank you, Dr. Goldberg. Let me just pull up the slides. So we'll look at the U.S. perspective. It, of course, inherited much from the United Kingdom over the centuries. And we'll take a look at the history and evolution of the mental defenses in American jurisprudence. It dates back to English common law, of course, and from for centuries, a key distinction made in the common law of the United Kingdom and the United States is the difference between the act, the actus reus, and the mental state, the mens rea. In order to commit a crime, both have to be present, both the behavior itself and the requisite guilty mind or consciousness of the wrongfulness of the act. And we'll see that this is a theme that has bedeviled the common law tradition as people try to figure out how to best balance these and to best understand them. And we'll see that addiction poses a very particular problem from the common law tradition of Anglo-American law. This is the most commonly used insanity defense in the United States today, but as we'll see, it has been modified in a variety of different ways. It was originally derived in its inception from the structure of the McNaughton test and distinguished between the capacity to appreciate the wrongfulness of the act and also had the so-called volitional prong, conforming conduct to the requirements of law. The McNaughton test lasted a long time. It was quite durable in the American tradition until the middle of the 20th century, and we began to see some modifications of it. The first, the McNaughton test, did create the prongs having to do with the nature and the quality of the act and the wrongfulness of the act, and was without modification for many, many years. However, states were becoming restless with this. From its inception, the McNaughton test had been criticized for being unable to reliably distinguish between what we would think of as sort of more on the wild beast test, the more ancient formulation of lunacy and insanity. And people had observed that it was less good at capturing acts which may be perfectly rational and seemingly to exercise a sound and well-balanced mind in terms of its intent and its planfulness, but that its ends may have been deranged. And so one effort to capture that was looking at the the criminal act itself as being in its totality the product of a mental disease or defect. But of course, it just ended up being impossible to consistently and reliably operationalize, because the way in which courts understood the term product made it extremely difficult. It was vague, it was difficult to apply, and very few cases could predictably come out in the same sort of way, even though they may have been similarly situated. In 1962, the American Law Institute crafted what is sort of a McNaughton version, but in an effort to modernize it, the states were roughly split on adopting this ALI test version, and it was also widely criticized. One of the primary criticisms was that it relied far too heavily on the medical model, using medicalized understanding of what a mental disease or defect might mean. It was also criticized for the use of words that were difficult to define and to consistently apply. For example, lacking substantial capacity to appreciate the criminality or conform conduct to the requirements of law, but retaining both the cognitive prong and the volitional prong. The states were roughly split on adopting the ALI version versus just maintaining the McNaughton rule. And so this was sort of a sideshow in American law for a time. But in the wake of the attempt by John Hinckley to assassinate President Ronald Reagan, there was renewed and significant attention to the insanity defense in the wake of that decision, that wake of that verdict. And as a result of the Insanity Defense Reform Act of 1984, the federal jurisdiction and many of the states simply dropped the volitional prong of the insanity test, making it entirely a cognitive test. In short, if the person appreciated the wrongfulness of their act, that was sufficient to convict. And this, of course, raises some special questions in the area of addiction, because if one drops out the elements of compulsion or of impaired judgment, simply ask, did you understand that breaking into your neighbor's house to steal things so you could sell them to buy heroin, addiction was really not going to play much of a role. Now, that was very consistent with the American legal tradition, in which addiction has largely reflected many of the cultural tropes and misunderstandings about the nature of addiction, particularly the pre-neuroscience understanding of the nature of addiction. Because in American tradition, if you voluntarily intoxicated yourself, you essentially were viewed as having assumed any of the risks that came with your voluntary intoxication, so you were responsible for them. This was a major complication generally for all kinds of things, but addiction poses, or perhaps it just brings a focus to the special problem of a brain disease process in which volition is itself impaired as part of the disease process. So the US Congress eliminated the volitional prong for federal cases. The ALI test, which had been the prevailing test in about half the states, it dropped down to being 14 of the 50 states. Around 28 states followed the federal government and took the volitional prong out, relying only on the cognitive prong. And 4 states retained the old combination of the McNaughton test plus an irresistible impulse test. In the course of the subsequent litigation around the insanity defense in the United States, the Supreme Court has become extremely deferential to the states in deciding for themselves what their pathway will be. And as a result, there are 4 states that really have no insanity defense at all. You can look at the slides that will be provided to you, but these are some of the changes that followed the 1984 Reform Act regarding the insanity defense. There was more focus given to the alternative that is in some states, but is not widely adopted for consistent practice. But at least 20 states have some variant of this guilty but mentally ill, in which the individual from a legal perspective is held responsible, but then must receive psychiatric care or other kinds of clinical care, either in a forensic hospital system before going to serve time in prison. They're stabilized and then incarcerated, or they go to prison but must receive care while they're for the mental illness. But it's clearly not a not guilty, it is a guilty but status. There have also been reforms in temporary insanity, and the states are all over the map on this. And it's hard to imagine that addiction, with the new neuroscience understanding of addiction, won't become more part of this conversation as the law evolves in that area. Although some states have completely rejected the defense of temporary insanity in its entirety. And finally, we may see some more action around addiction in diminished capacity, but about half the states don't have a formal diminished capacity, although I will say that many, like Massachusetts, which will tell you as a formal legal matter, we don't have diminished capacity. In fact, as you can see from this case citation from Massachusetts, there is something that certainly looks like diminished capacity, although they may not want to call it that in the legal system itself. These are some additional cases for you to look at that bear upon its implementation of the insanity defense. And my summary, there's immense variation. We shouldn't be wildly surprised amongst the 50 states, and if you include the US territories as well, immense variation, and each iteration of the test reveals the ambiguities and the tensions in the way that we try to understand appreciation of wrongfulness and capacities to conform conduct, the volitional prong. And I think the challenge of addiction sits squarely in that long and uneasy tradition. And with that, I will pass this on to Professor Rove.
Thank you, Dr. Kincher, for this very interesting and excellent overview of the American possibility to invoke insanity defense related to addiction. And we are going to continue now with exploring how within the European legal systems similar questions can be addressed, because one of the didactic approaches of the course of the executive diploma is exactly to explore how the use of neuroscience may be differently embedded within different legal systems. And the topic of addiction and criminal responsibility is, of course, an excellent case study to see how different systems deal within their definitions of criminal responsibility and legal insanity with a problem like intoxication and addiction. So let me share my screen. So I think that goes well. So just like we explored from the American perspective, if you want to understand how intoxication, addiction, and criminal responsibility relate, we first have to define the appropriate insanity defense. And I want to do that within two systems. I want to explore that from the Dutch perspective and later on from the German perspective, because I think the comparison is also very fruitful to create a kind of debate on which systems seem to allow to address addiction most appropriately. If you look at the Dutch approach, the Netherlands, the insanity defense is defined in Article 39 of the Dutch Criminal Code. And in essence, it means that anyone who commits an offense for which he cannot be held responsible by reason of a mental disorder, a psychogeriatric condition, or an intellectual disability is not criminally liable. We should know that under the European continental systems, an insanity defense, or a non-accountability defense, as it's called in the Netherlands, addresses not so much the mens rea, the descriptive mens rea like intent, but is addressed on a separate level in the liability scheme, which Dr. Goldberg already mentioned, referring to the so-called tripartite system. It addresses the blameworthiness of the liability, hence the excusing nature of the insanity defense. This definition is reflecting the insanity defense as a full excuse, but we should know that case law accepts Article 39 also as a partial defense leading to diminished responsibility, in principle applicable for all kinds of offenses. So not only for murder, for example, but for all kinds of offenses, 39 could lead either to a full excuse or a diminished responsibility. What draws our attention immediately, if you compare that with the American definitions we have just explored, is that this insanity defense in the Netherlands does not give clear criteria when the insanity could be successfully accepted. It only says there must be a connection between a disorder and a crime. The advantage of that, if you can call this an advantage, is of course an enormous flexibility in the application of the insanity defense. Since it's not specifically mentioned which capacities should be impaired by which disorders, behavioral experts and the courts develop their own criteria, and in practice that means that both cognitive impairments, lack of rationality, think of a psychosis for example, but also volitional impairments, and these are of course very interesting in addiction-related cases, also volitional impairments are accepted. The disadvantage, of course, of such a quite broad, open definition of insanity is that it all depends on the courts which form of impairment you will accept under which conditions, and that doesn't create much legal certainty. So if we now look how these rules are applied on intoxication and addiction, we see some interesting ideas popping up. If we focus on voluntary intoxication or substance use, whether the defendant is addicted or not, then what is crucial and essential in the Dutch system is that they favor an extremely broad prior fault rule. In essence, it means that anyone who uses drugs or alcohol knowingly and willingly, by doing that, accepts the chance of losing control over one's actions. More can be said about that, but that's the essence. So in other words, prior fault almost is identical with any form of voluntary intoxication. There is no concrete foreseeability demanded with regard to the crime that is committed, for example, like bodily assault. Admittedly, this is seriously criticized because in the end, the moment you become seriously drunk or otherwise intoxicated, you're responsible for all the offenses that are committed afterwards. How does that relate to addiction? Well, there we see a very varied, diverse view. Exactly because the insanity defense rule is so open. Some case law seems to accept diminished responsibility. For example, when the defendant commits the crime under the influence of withdrawal symptoms. But if you look at the issue of prior fault, then we see a very diverse view in the sense that some courts are more lenient than others. In general, the prior fault rule is very stringent and doesn't happen in much cases that addicted-related crimes, that prior fault will not be accepted. The prior fault is very often a problem there. Another problem is comorbidity, as Dr. Goldberg mentioned. In reality, of course, there is hardly any case which is only focused on addiction or even only on intoxication. Very often there are underlying disorders, sensitivity for psychosis, for example, or a depression or an anxiety disorder, as was also mentioned in the Haley case. And then the main legal question where courts struggle with is obviously what comes first. What was first? Was it the disorder? Was it the addiction? What reinforces each other? And there seems to be a tendency that when one assesses chronologically that a disorder precedes the addiction or the intoxication, that one is then more inclined to allow diminished responsibility. One may wonder whether that's always a correct reasoning, because the causal connection between these different issues is, of course, not always that linear. And you also see an increased use of neuroscientific tests and models in Dutch criminal law cases, albeit still a little bit limited. I think the problems of addiction can be very well illustrated if we go to one specific case, very famous case in Dutch criminal law in this field, a case of an amphetamine psychosis. It happened 15 years ago, where the defendant was severely addicted, used amphetamine for 4 years, and when he used amphetamine, he was in a psychosis, resulting in the attempted murder of his girlfriend and the actual murder of her 2 children. In his mind, when he was suffering from his psychosis, he really believed they were attacking him, that they were dangerous. If you look at how this case was dealt with legally, we immediately see how courts struggle with the addiction. At first instance, the court made clear that people who commit crimes under the influence of substances, that they are in principle responsible for their acts, because they simply voluntarily choose to bring themselves in this kind of condition. So you immediately recognize here that very broad prior fault rule. There was still accepted diminished responsibility, but that was due to another disorder, namely his narcissistic personality disorder. The outcome was that he received 18 years imprisonment. In appeal, we see a striking difference. Suddenly the court in appeal accepts a diminished responsibility purely on the basis of the autonomous addiction disease that limited the freedom to determine the will. In the end, the punishment remains the same, but what strikes here is the focus on the addiction. And if you look at how the experts formulated their advice in this case, you see a wide disagreement. The first expert really was an addiction expert and also used this neuroscientific perspective on the assessment, made clear that although the defendant may have freedom in choosing to start amphetamine long time ago, the substance use and the addiction had irreversible effects on the brain that limit the freedom to determine one's will to use substance, and hence the plea for strongly diminished responsibility. So that's a clear reference to addiction as an autonomous disease. But if you look at the 2 other experts, they have a completely different perspective on how to evaluate the addiction. One expert focused on the fact that since the defendant already had in the past experience with the bad effects of his amphetamine use, he should be considered fully responsible. Again, a prior fault rule. And the third expert could make a case that the defendant is maybe not responsible for his offense in principle, but in the end he still is, because he is ultimately responsible for having becoming addicted. Whether that's sound reasoning is, I think, open for debate. But the Court of Appeal followed that first expert. Interestingly, this was not the end of the case. For procedural reasons that are not that important for now, another Court of Appeal evaluated this case, and this court came to the conclusion that the defendant is still diminished responsible, but that the addiction did not play any role for the assessment, because he had chosen to voluntarily start to use the amphetamine, the drugs, and that he continued using it. And this is an interesting argument and motivation, because what it seems to say, if you're a little bit cynically, you can conclude that it's precisely because the defendant had a lot of expertise, so to say, as a result of his addiction, what the effects of the amphetamine could be on his psychological well-being, that's exactly held against him. And I think you can't present a bigger difference between this Court of Appeal decision and the previous one, where the addiction was really taken seriously. Let's now go to Germany. Again, we have to start, how does the insanity defense look like? Or as the Germans call it, Schuldunfähigkeit, the incapacity of guilt defense. In section 20 of the German Criminal Code, they accept a full excuse. So you can have a full insanity defense. And on a footnote, that was one of the main sources of inspiration, by the way, of the American Model Penal Code insanity defense. And in essence, it means that if the defendant, due to a wide range of possible disorders, is incapable of appreciating the wrongfulness of their actions, or cannot control himself, not acting in accordance with such an appreciation, then there is no criminal liability. That's quite exceptional. Most cases will only lead to the diminished responsibility defense, so the partial defense variant of section 20, which means that if these capacities, either of a cognitive or a volitional nature, are substantially diminished but not completely impaired, the sentence may be mitigated. What does that mean for either intoxication, substance use, and addiction? If you look at the intoxication, and we don't only have to think about drug-related cases, most of these cases are also alcohol-related, alcohol abuse. And the law in Germany is traditionally mostly based on that. If you look at intoxication cases, whether one is addicted or not, the intoxicated state, even voluntary intoxication, can be qualified as a profound consciousness disorder. But of course, a voluntary intoxication, we cannot allow that leads immediately to impunity. So Germany has developed a twofold system, more nuanced than the Netherlands and the American system, namely that it clearly distinguishes between two scenarios. Either there is prior fault or there is no prior fault. And what is particular is that the Germans have defined prior fault more strict than the broad prior fault rule in the Netherlands. In the German way of thinking, prior fault is only present if you had a concrete foreseeability of committing an offense as a result of your intoxicated state. If that's present, such a foreseeability, you can't have any defense. You're liable for the original offense. Let's think about bodily assault, for example. But if there is no prior fault, and there is much more room and space to accept that there is no prior fault, given the strict definition of prior fault in Germany, and the intoxication is so severe, the drunken state, for example, is so severe that there is a complete impairment of control, then you can invoke, in principle, a full insanity defense. But to prevent impunity, the German system has allowed an alternative liability instead. Namely, you will be liable for the offense of dangerous intoxication, of making yourself intoxicated, not in order to commit a crime, not because you foresee a crime, but simply because as a result of intentionally intoxicating yourself, a crime has been committed. It's a kind of endangerment offense. That twofold system is, I think, quite unique in comparison with other legal systems of how to deal with intoxication, because it's clearly a normative distinction between becoming intoxicated, knowing that there is a risk of a crime, on the one hand, prior fault, and becoming intoxicated without any risk of committing a crime, but nonetheless, a crime will be committed. You commit bodily assault or destroy property, then you will have that alternative offense, which still has a maximum sentencing of 5 years. To conclude, how does the German criminal law address addiction? Addiction is formally qualified as a pathological mental disorder. So in principle, you can invoke a full insanity defense or at least partial diminished responsibility defense. Practically, a complete exculpation is very rare, is exceptional, but that's true for the insanity defense as a whole. Only in cases where you have multiple drug use and comorbidity, you can see the possibility of a complete exculpation. But in most cases, it will be a partial defense. And what is quite unique in that German perspective is that the German Supreme Court already in the 70s, made a landmark case where they defined clear criteria where long-term substance use should play a role in assessing the liability. Namely, when 3 criteria are fulfilled. One of these 3 is sufficient. Either the addiction has led to serious personality changes, or the defendant was suffering from serious withdrawal symptoms that drove him to procure drugs through a criminal offense. Or thirdly, when the defendant commits an offense in a state of acute intoxication, which we already discussed. That second possibility is, of course, very intriguing because it points out that when the addicted offender commits a crime motivated by serious withdrawal symptoms and the loss of control in order to procure his drugs, that could be a reason for diminished responsibility. It's very strictly applied. It doesn't mean that when you commit theft or burglary or shoplift in order simply to finance your drugs, that will lead to a diminished responsibility for these offenses, because the motivation must be linked to withdrawal symptoms. And in recent case law, it's even broadened that in individual cases, an extreme fear of serious withdrawal symptoms may already be sufficient for a diminished responsibility. So I think we can conclude that these criteria formulated by the German Supreme Court really try to make a nuanced perspective on the potential role of addiction for criminal responsibility. Practically, that could lead to the possibility of a custodial addiction treatment order in accordance with paragraph 64 of the German Criminal Code. Is there still room for accepting prior fault with an addicted offender? That's possible. But interesting is that the German case law explicitly states that an addiction in itself cannot be considered a prior fault. You cannot be blamed for being an addict, and being an addict then consequentially linked with a responsibility for the crime. Much more is needed for a prior fault assessment. That has to do with the reluctancy of German criminal law to accept what they call a kind of Lebensführungsschuld, kind of status criminality or lifestyle blameworthiness. So the prior fault for addicted offenders still has to be assessed, but on an overall individual case-by-case assessment. So for example, if you are dealing with an addicted offender who knows that in certain conflictuous situations, he may lose his temper or suffer more from his withdrawal symptoms, then he still has the duty to prevent these situations that may trigger him. And that could constitute a prior fault if he doesn't take these precautions. But addiction in itself is clearly not prior fault. And I think that's also very interesting for the debate. To conclude, if we look at the comparative perspectives that are now presented, then I think there are some questions that are quite straightforward. If we ask ourselves when and how should addiction be a partial excuse or a full excuse, we already see comparatively that that question has to be answered differently in different legal systems, because in some systems, the possibility to invoke an insanity defense is quite limited. But if an insanity defense would allow it, then of course the question is, should we develop certain criteria, partly or fully grounded on neuroscientific insights also, that allow us to determine when addiction should play a role, like the German Supreme Court has tried to do. And what should be the role of prior fault? Already Dr. Goldberg mentioned that what do we consider culpable behavior? Is there not a risk that we are going to blame the defendant for being addicted? Is that not something we have to prevent? And what kind of foreseeability is required in these cases? A general one, if you use drugs, well, then anything that can go wrong, that's for you to pay, or a more concrete one? And should we also incorporate giving attention to the volitional problem that addicts have also in preventing their prior fault situation. And broader policy discussions are, of course, necessary. Should we not contemplate more fundamental changes within criminal law, especially also with regard to sentencing? And maybe this debate on the potential role of addiction informed by neuroscience in the assessment of criminal responsibility should also help us to start a discussion on what constitutes a good legal insanity defense. What should be the criteria for legal insanity and diminished responsibility? And how can neuroscience contribute to this debate? With that, I would like to end my part of the presentation, and maybe some of these questions can be further explored.
Thank you very much, David, and thank you very much to all our speakers for the insightful discussion and for addressing some of the very complex issues stemming from the interconnection between addiction and insanity defense, and also for analyzing how neuroscience can inform the law from a comparative perspective.